Good afternoon, dear guests and dear students. Today, we are very privileged to have a session on IPR, intellectual property rights. We all do a lot of intellectual works, but do we know about the rights? Are we violating the rights? Are we aware about that? Now, we are going to hear from a very distinguished person regarding all this. Under the National Intellectual Property Awareness Mission, Ms. Lavanya Madhuri, examiner of patents and designs and NIPAM trainer from Indian Patent Office, Chennai, is taking us a session on IPR awareness. I wholeheartedly welcome you, ma'am, to this program. Invoking God's blessing, let's have a silent prayer and let's start the program. Once again, I welcome you, ma'am. Over to you.
Thank you, sir.
Abhinay,
Is my screen visible, sir?
yes, ma'am. Ma'am, your audio is a little feeble.
Sorry, sir.
It's fine, ma'am.
Okay. So I can start the session, right?
Yeah, your screen is visible, but it's not presentation mode. All other participants, please mute your audio.
Okay. So on behalf of Intellectual Property Office Chennai, I'd like to welcome all the participants, coordinators and staff members of Marian College. So this session is about on behalf of 75th Azadi Ka Amrit Mahotsav. So this session is about the intellectual property and its rights, to create awareness about these rights to the students and also to inculcate the spirit of creativity and innovation among the students. So before going to our session, this is about the disclaimer on copyright, which states that no part of this session will be recorded or taken screenshots, anything will be recorded. So it should not take such things, and because it violates the copyright and without our permission, it should not be done. And proceeding with the session. So in this session, we will see what is intellectual property, what are its rights, and what is the significance of intellectual property rights, what are the types of intellectual properties, and how we differentiate the intellectual property rights, and what is the patent filing procedure in India, how we decide the patentability, and what is the difference between the research paper and the patents, followed by some quiz. So what is intellectual property means? So like other properties like land or a house or a vehicle, this is also some kind of a property. In case of a land, we can see and can touch the things. Those are the tangible properties, but this intellectual property is an intangible property. So whatever the creations of our brain comes under intellectual property. It may be an invention, it may be related to technology, it may be related to creative work. So a painting, song, symbols, or any business related trademarks, all these comes under intellectual property. And the rights associated with this intellectual property are called intellectual property rights. So, and the most important thing about this is all the intellectual property rights are territorial in nature. One has to remember this point very sincerely, because all the intellectual properties are territorial in nature. Suppose if you get any right, if you get any registration in India, you can enjoy those rights only in India. You cannot go into the other country and sue those people. For example, if you get any patent in India, you can utilize those rights only in India. You cannot go to the other country like China, and you cannot sue them because of using your work. In order to claim those rights in other countries as well, you have to file the related intellectual property like patents or designs in those countries as well. This is because laws and regulations are different from different countries. For example, if you see in China, mostly defense cases are also get given grant. But in India, defense cases are not given any patents. Similarly, medical methods like method of operation or method of things, method of diagnostic, all these comes under Section 3A of Indian Patent Act, which are not patented. But in case of other countries like United States, they are patented. As the laws are different in different countries, all the intellectual property rights are territorial in nature. So protect your intellectual property. So if you take any business or any person, copying, infringement, theft are the major threats to your business. So suppose if I have done some invention and it has some commercial value, so I haven't filed for a patent. So without filing the patent, I started using that, selling that in the market. So other big company has seen my product and found that it has more major commercial value. So as I have not got any patent for that, they simply copied my work and they start selling their own work. So as that is a big company, their range of marketing will be more, and more consumers will buy from that person. Then because my identity is less, I will be losing my credibility and also losing my business. As I have not got any patent for my work, so I cannot sue against that big company. So in order to avoid all these things, because if your work is not registered or is not granted, other person can easily copy your work or easily take your work and get the credibility and the business on their name. So in order to avoid all these things, one has to protect their intellectual property. That means if the work is related to inventions or technology, one has to get a patent before entering into the commercialization of the product or before entering into the market. Similar to the copyrights or creative works like writing books, novels, filmmaking, all such things should be registered so that it will be having a legal proof to fight against those people who copy your work. Significance of intellectual property. So first thing, suppose if you have a land, what is the first thing you will do? You go to the register office and get it registered on your name, so that you can say to the other people that so and so land and so and so acres are on my name. You should not enter into my land without my permission. In the same way, if you have any work, if you have done some work, it may be a creative work or it may be a technical work, if you feel that it can be registered and it can get grant, then first thing you have to do is you have to file for that in the appropriate office. Then you are indirectly saying to the people that saying that this is my work, this is my technology, so don't cross my borders without my permission, don't use my work without my permission. So in the case of the land, after registering, what you will do, you are excluding others, and you can in the same way in this intellectual property also, after getting registered, you can exclude others. Third thing is, in the case of a land, so after registration and after excluding others, you can use that land for your own purpose, or you can give it as a rent to the other people, or you can build a mall, or you can use it for the agriculture purpose. Like anything you wanted to do, you can do. In the same way, if you have an intellectual property on your name, you can use it for your own purpose. You can enter into the market, or you can sell that work to the other companies, or you can give the license to the other companies like that, and you can also expand your business horizon. So with the intellectual property, you are getting the protection and you're also excluding others, and you can utilize the work for your own purpose or for the development of the society. What does intellectual property offer? So intellectual property definitely gives the awards and rewards. For example, if a student has done some work in his college and he got the patent, or if he has filed for the patent, definitely his his weightage in his resume. Suppose if he goes to other company to join for a work, so when a person sees that he has got a patent or he has filed for a patent, definitely his weightage, he will be more accepted into the company to get a job compared to the other people. So it will give the due recognition and awards and rewards. Earn money as royalty, incentives, etc. For example, after having the intellectual property on your name, you can use it for your own purpose or for the royalty. Suppose royalty and incentives means you can completely sell the work you have done to the other person, or you can give it as a license to the other person. The difference is, so if I sell my work, that means I am selling the everything related to the work. For example, if I have done some work and I got a patent, so Google is interested in my work. So what the Google will put in front of me is, they will give two options, whether to completely sell my work to them, or they will ask for the license. So in case of complete selling means I am giving everything related to the work. Even the permission, the patented, I am transferring my patent rights to the Google company. Licensing means the patent rights will be on my name, but I'm giving permission to the other company like Google to use my work. So I'm giving, licensing means in exchange of some royalty, I'm giving the permission to the other company to use my work. And in case of a technology transfer means completely I'm transferring all my rights to the other company. And commercially sell without fear of copying. So after having a registration or a grant on your name, you can without any fear enter into the market. So even if someone copies your work also, you have a legal proof saying that this is my work, you should not copy that. So you have a strong legal proof to fight against the infringers. And new innovations will happen. So how new innovations happens means, for example, if you see the telephone first invented by the Alexander Graham Bell, and he got a patent for that. So if there is no such patenting system, so if there is no patenting system, what he will do, he will not come to the society and disclose his work, because he will be having a fear that, okay, if I disclose my invention, people will copy that and I will lose the credibility, or people will copy that and people might use it for the wrongful purposes like that. So as there is a system called patenting, and as you're also getting the protection for your work, so you can fearlessly enter into the society and say to the people that this is my work. And based on that, as Graham Bell has invented the telephone and he got patent for that, after that you can see a lot of innovation has happened based on that. So a huge telephone has transformed to a portable telephone and wireless telephone. Now if you see smartphones, you are doing a lot of things on your mobile phone. So if the Graham Bell has felt that I should not disclose my invention to the society, these many innovations may not be happened. So definitely, if a patent system exists, if an intellectual property protection system exists, people will without enter into the society without fear of copying the other, without fear of copying. So based on those people's work, many innovations and many marketing businesses will happen. So the next point is increase the value of college faculty members and students. And the next thing is the economic growth of the country or the world. Types of the intellectual property. So first thing is patents, designs, trademark, copyright, geographical indication, semiconductor integrated circuit layout designs, and other types of intellectual property. So first we will see what is patents.
Excuse me, Lavani ma'am.
Yes, sir.
Ma'am, the slide is not changing, I think.
Okay.
We can see only the first page, like the IPR awareness program and your name.
Okay, now can you see, sir, this graph?
Yeah. Despite a substantial decrease in
Yeah,
filing or
yeah.
grading. Yeah, it's a chart.
Okay,
Hope
sorry
all the
for the
students.
moment.
Yeah. Now it is okay.
Okay. So I have said about what is intellectual property in this slide. And after that, I moved on to this, why to protect your intellectual property. And here I explained about the land example along with the, what is the significance of protecting the IP. This is about what does intellectual property offer. So now we are seeing the first one, that is patent. So in this graph, if you see, first one is China. China has filed around 1.4 million patent applications in the year 2019. If you see, India has filed around 53,000 applications in the year 2019. But if you see here the percentage, in China, there is a decrease of 9.2% of patent filing compared to the previous years. But if you see in India, there is an increase of patent applications by 7.1%. So that means a lot of innovations are happening in India and a lot of awareness about the intellectual property is happening in India. That's why there is a substantial increase in the patent filing in the country India. And if you see in the right side, GII ranking, that is Global Innovative Index ranking. In the year 2015, it is 81. In the year 2021, it is 46. There is an increment in the rank of India from 81 to 46. That means this depicts that there is a lot of innovation is happening in the country India, and also a lot of multinational companies are also showing interest in the Indian market. That's why there is an increase in the rank of the India, and also the global image of the country also improves with as the patent filing in a country improves, the global image of the country also increases. So now we will see what is patent. A patent is an exclusive right granted in respect of an invention. Patents are given to those things which have a technical solution. Suppose that means if there is any technical problem and you are solving in a technical way, then it can be considered for granting a patent. What is main thing to be for getting a patent is the invention should consist of a new and inventive solution. Then it can be considered for a patent. So after getting a patent, you are getting the exclusive rights in order so that you can exclude others in using, making, excising, vending, and importing of your work. So it will be the exclusive rights are given for a period of 20 years in exchange for disclosing your invention to the office. So there is a misconception that patents are given to the most complex inventions or the inventions which have large technical features like that. But in general, patents can be given to the simple inventions as well. For example, if you see here, if you see the first picture, you can understand that it is a baby's hat which is designed or developed to avoid the contact of water in the baby's eye. If you say there is nothing much technical invention there, it is simple baby hat which is used to avoid the contact of water in the baby's eye. Even this also got patented. If you see the second one, this is a self-driving car and electric car. So there will be a lot of inventions related to electrical, like battery management or communications. So a lot of innovation will be there in this. So it is the most complex one. So a patent can be given to the simple ones and also the complex ones. As here, if you see, I'll explain the technical problem in these two pictures. The technical problem here is to teach a child how to brush. So the technical solution is given in two perspectives. This first one is an US application. The second one is an Indian application. So in the first US application, if you see, what they did was they inserted some sensors in the brush and also some transmitters, receivers, so that it will generate so that sensors will detect the position of the brush in the teeth, and it will transmit the data to that monitor, and the monitor will display the image of the brushing position, and it will also guide the child how to brush. But if you see in the second figure, what this Indian inventor has done is he simply added the beads. Beads means which will make sound whenever it is moved. So the correct way of brushing is one has to move the brush vertically, not horizontally. So he simply used that idea, and he developed these and arranged those beads in such a manner that only whenever the brush moves in a vertical manner, it will make a sound. If it moves horizontally, it will not make sound. So just a parent who listens to that sound might understand that, okay, his child is brushing the teeth properly. So if you see in the first figure, there are a lot of technical features are present. But in the second one, simple features are added to solve the problem. So we can say that Indians are very good at innovation, but what they lack is the awareness about that, and what they lack is getting it right on their work they have done. There is nothing called a big invention or a small invention. So whatever might be the invention, they can be protected under patents. Now we will see some different examples in the other fields. So the first one is in the LED glowing stumps. Earlier we used to use wooden stumps in the cricket matches. So the decision making was very difficult. So whenever a ball touches, the umpire used to take a lot of time to recognize whether ball has touched or not. So nowadays we are using these light glowing stumps, which will detect even if a feather falls on that wicket, it will detect that and it will glow. So the decision making was very easy. So there is one interesting thing about this invention is, earlier I said, all the intellectual properties are territorial in nature. Suppose if you get rights in India, you can enjoy those rights in India. So this invention was done by an Australian inventor. He himself got a patent for that in Australia. So cricket is a major business in most of the countries like Australia, New Zealand, England, and also in India. So if he apply only in Australia, he will get those rights only in Australia. So other country people may use his work, so he will not be getting much royalty from other country businesses. So what he did was, along with Australia, he has filed for patent in other countries as well, like in New Zealand, India, England. He also filed for the patent in other countries, and he got granted. So now, whenever the association uses these stumps, light glowing stumps, that association will pay some royalty to the patentee. The second one is a 3D printed building. It is in our IIT Madras. And the third one is a defibrillator. This is also a patented one, which will give the electric shock to a person whenever he got a cardiac arrest. So the fourth one is, all of you know that there is a fuel cell electric technology. So it may be related to the battery management or the charging of the batteries, like that. So if you see a lot of whatever may be a thing, suppose a mobile phone or a computer, a lot of innovations will be there in that, but we cannot identify that. If you see this mobile phone, each and everything is a patented one. That the touch screen or the lock unlock button, video display, speakers, recorders, and camera, all these are the patented. So a simple mobile phone will consist of these many patented inventions in a mobile phone. So till now we have seen that how patent helps in protecting the inventions. So suppose if my product is more innovative one, but it doesn't appear good, so people might not be comfortable to buy my product, because though it might consist of very innovative work, but the appearance of the product is not up to the level of customer satisfaction. So the customer may hesitate and do not buy the product. So in order to avoid that, design plays a major role in attracting the customers. So for example, if you see these two figures, can you identify these products? Can anyone identify these two products? You can use chat box.
Harpic.
Yes, Harpic is correct. And next one? Okay. The next one is
Calling.
yes, calling. Correct. So if you see here, nothing is mentioned on the bottles, neither the product name or the company name or the purpose of the product. Nothing is mentioned. But just by seeing the colors and the shape of the bottle, you are able to identify the product names. That's why even the design plays a major role in identifying the product, and that's why the products of the companies are communicated, the brand is communicated through the designs. So what is design means? A design is a features of shape, configuration, pattern, ornament, or composition of lines, colors applied to any article. So here you might be seeing the furniture example, ornaments, designs, pressure cooker shape. So what appears to the eye is judged in the design. So it should be new and original to get a design registration. The other examples are the costumes here, the gagra work, ornamental work on these gagras, or the saris, a coat on the coat, and the different color patterns on these shirt, like that also comes under the designs. And the shapes of the bottles also comes under the designs. If you see, this is the same Dove moisturizer, but it is available in different shapes in the different markets. This is the why they will do is to attract the customers in those areas. And even mechanical designs also comes under design registration. And if you have seen some Star War, that Captain America shield also has given a design grant, like that. And Coca-Cola bottle, that is also a design registered one. So now till now we have seen patent for technology, designs for the appearance of the product. Now we will see trademarks. Trademarks, in simple words, we can say it is a brand image of a product. What is trademark means? A trademark is a sign capable of distinguishing the goods or services of one enterprise from those of the other enterprises. So if you see here, the first one is Nike, Adidas, Puma, McDonald's, and Pizza Hut, Domino's, FedEx, Blue Dart, Indian Post, all these comes under the trademarks. So what comes under trademarks means brand name. That is brand names like Nike, LG, Coca-Cola, these comes under the trademarks. Taglines also comes under trademarks like just do it, life's good, open happiness comes under the trademarks. Next one is sound mark. So if you see, whenever you switch on a Nokia mobile, you will get a unique ringtone or a unique tone, sound mark. That also comes under trademarks, because just by listening to that sound, you are able to identify that it is a Nokia mobile. Even the Britannia ad, Netflix sound, all these comes under sound marks, because you are identifying the brand based on those sounds. That's why that also comes under sound marks. Next one is logo. Logos like this tick mark, M symbol, all these comes under the trademarks. What can be used as a mark means it can be a word, it can be a letter or a logo, numerical, drawing or picture or labels. These can be formed to get a trademark. From a commercial point of view, trademarks plays an important role, a very major role, because you're attracting the customers through the brand image. So branding is a very important. So if you go to a shoe shop, there is a Nike brand, there is Adidas brand, there is a normal one. So if you are able to buy the high value product, definitely you will go for the branded one, because somehow you think that the branded one has a good quality. So the quality is assured, like that, you will think that. So even if you have to differentiate the Nike and the Adidas, the shoe shape will be different, color might be same, but how you are differentiating the two companies' shoes means just by the logos like tick mark, Adidas symbol. By that you are differentiating the two products. So why it is important means it is not just a name or a symbol or logo. It is actually you are able to identify the brand. And it also distinguishes the source of goods or services from one trader from those of the others. So you are able to differentiate the products from one company, like this belongs to Nike or this belongs to Nestle. You are able to differentiate the products. Allows a business entity to build public goodwill and brand reputation. And it also assures the good quality of services. How to indicate your trademark means, suppose if any company's name has a TM besides that name, then we can say that the trademark application has been filed. If it consists of an encircled R, it is said that it has been registered, that particular name has been registered as a trademark. You will be observing these two marks in the shop names as well. If you go in any market, you can observe this. You can differentiate whether the product name or the company name is a registered one or not. So we'll take some quiz here. So in this crossword puzzle, there are some daily usage products. So can you identify those products in this puzzle? Can anyone identify the products here? If you want, I can give hint also. You can use the chat box. Yes, Tata is correct. Then you can use the chat box also. So Tata, I can give hints. Pepsi.
Cadbury.
Yes, Cadbury is correct. Your name, please.
Karen.
Okay, the answers are correct. And any other brand names?
Ma'am, Pepsi.
So I'll
Ma'am,
show.
Amul.
Yes, Amul, correct. So I'll reveal the answers.
Dettol.
Yes, Dettol, correct. So Pepsi, Amul, Dettol, Horlicks, Cadbury, Bubble, Lux, Tata, Bata, Link. So can you identify what is wrong in these two pictures?
The second picture, it's Pisleri, not Pisperry.
Yes, correct.
And Puma, not Poma.
Yes,
Puma.
correct. Yes. So as the original names PUMA and Bisleri or the trademarks one, they cannot directly use their name directly. But they also want to confuse the customers. So they change slightly the names like PUMA to PBOMA. So some people who are not aware of that, they will think that this is the original brand and they are getting in a less price. So they will buy those products. This is also one kind of infringement which should not be done. So now we will see copyrights. So copyright is an exclusive right granted to the creators for the expression of idea. So whenever a person writes something, the copyright comes into existence at that moment of time. There is no need to register it from the office. But why we recommend it to register in the office means because you will be having a strong legal proof. Suppose if a person writes some story in his diary on so and so date, so he lost the diary and someone used that idea and he made a film. The other person made a film. So he understood that it is his work and he filed a case against them. So the court asked for the proof. he cannot show the proof, and even if he shows his story written in his diary, it cannot be considered as a legal one, because anyone can write the same thing in a piece of paper. So that's why it cannot be considered as a legal one. Suppose if that person had already registered in any film association or any in our IP office, in those cases, he can directly show that as a proof to the court, and the court will accept that as a proof. That's why we recommend to get it registered as a copyright under appropriate office. So copyright is for the expression of an idea, not for the ideas. So if you see, there will be a lot of love stories, but they will express it differently. Suppose sometimes screenplay will be different, dialogues will be different, and the scenarios will be different. So the copyright is for the expression of an idea, not for the ideas. So what comes under copyrights is literary work, paintings, photographs, drawings, films, music, choreography, sculpture, all these comes under the copyright. So what is the term of a copyright means? Suppose if a person has written something, that will be considered as a copyright till the lifetime of the person plus 60 years after the death of that person. Suppose if any company publishes the work, in that case, it will be 60 years from date of publishing the work. Like if you see all the books written by Gandhiji has comes under the copyright law till the person is alive, and after Gandhi has died, till 60 years it was under the copyright. Now it is not, it is an open source. So if you see any music song or released by T Series or Sony Music, so from that date it will be under copyright to the next 60 years. Now we will see semiconductor integrated circuit layout design registry. So if you see, all the devices are becoming compact. So the size of the products is becoming very less. So if you see the mobile phone, the smartness and the size and the volume of the mobile phone is decreasing day by day. So there will be arrangement of the components inside this mobile phone. So how we are arranging those components in a device comes under semiconductor integrated circuit layout design. It is nothing but the arrangement of the components like integrated circuits or chips or the resistors, thermistors, heat dissipators on a printed circuit board. The arrangement, the layout of all these things on a printed circuit board comes under SICLD registry. Now we will see geographical indication. Geographical indication means, in a simple words, we will be using it as a GI tag. So a geographical indication is a sign used on products that have a specific geographical origin and possess qualities or reputation that are due to that origin. So some of the examples are Edayur chilli, Tirupati laddu, Madalam of Palakkad, Mysore sandal, Kanchipuram silk, Neelambar teak. So you will be seeing a lot of people growing the chilies in different areas. But Edayur chilli has specific quality and taste. That taste and quality comes because of that place called Edayur. That's why it is considered as it is given a GI tag. As I said, GI tags are given to those products that have a specific geographical origin. These are some other examples: Dindigul logs, Kashmir saffron, and Darjeeling tea, like that. There are some other types of intellectual property like plant varieties, but this comes under the Ministry of Agriculture. So, and the next one is a trade secrets. Trade secrets, you can say the Coca-Cola recipe, KFC chicken recipe, and the Google algorithm, all these comes under trade secrets. So they don't disclose the complete recipe or the complete algorithm, but they hide that with the government. So the protection will be of lifetime. So it should not be revealed to the other people. But trade secret is not considered as an IP in our Indian government, but in USA it is. So that's why they are protected under trade secrets in the other other countries like US, other countries. But in India, trade secret is not an intellectual property. So next to intellectual property is traditional knowledge. So traditional knowledge means, so we might be listening from our grandparents or great grandparents, ancestors, that turmeric is very good for health benefits or for the beauty as a cosmetic product, like that. So we have known about this from ages. But the other Western countries like Europe, USA, they may not know about the benefits of turmeric, but they simply get a file for a patent and get a patent. So in order to avoid, so if any person get a patent, he is restricting the other people to use that freely. So in order to avoid such uh, in order to avoid that, so what our government did is they developed a database along with other countries. They can save their data, the traditional knowledge like neem leaves as a antifungal agent and turmeric for the beauty purpose or health benefits. So they developed a database where they can store all these traditional knowledge in the database, so that any person cannot get the patents or exclusive rights for those things. IP everywhere. So if you see, you will be seeing a lot of intellectual property around you, but sometimes we cannot differentiate what is patent or what is a design registered. So if you see a laptop, that Apple logo comes under trademark, and the shape of the laptop comes under designs, and the technology inside that LED display or mouse pad, that comes under patents, and the user manual you will get with this product comes under copyrights, and the arrangement of the components comes under SICL designs. So inventions of mobile phone protected by patent, and brands are protected by trademark, and the design of that mobile phone comes under industrial designs, and the software installed in that or the music ringtones comes under the copyrights. For a patent, it will be 20 years. So if you get a patent, you will enjoy those rights for 20 years. There is nothing called global or international patent. All are territorial in nature. And the design is for 10 years, and they can extend it to the next 5 years. Trademark is for the indefinite period of time, but you have to renew for every 10 years. GI is also for indefinite period of time, but you have to renew every 10 years. So copyright is for the artistic works, and it will be lifetime of the author plus 60 years. So who can apply for intellectual properties? Any person, either it may be individual or a group of people or a company or a startup, any person can file for the intellectual property, or on behalf of them, they can take a legal representative help to file for these intellectual properties. So all rights are territorial in nature. So this is a summary. First, patents are given to those inventions and innovations. The duration is for the 20 years. Design is for the appearance of the product. The duration is for the 10 years, and it can be extended to the next 5 years. And trademark is a distinctive sign or marks to identify and distinguish goods and services. It is for the indefinite period of time. It can be renewed for the next for every 10 years. Copyright is for the artistic works. It is the lifetime of the author plus 60 years. In other cases, it is 60 years. Geographical indication is the product originating from specific location, which gives that the product is unique and differentiating quality. It is also for the indefinite period of time, but it can be renewed for every 10 years. SICLD is the arrangement of components on a printed circuit board, that is for the 10 years. So as I said earlier, Indians are very good at innovation and invention, but they lack the awareness of getting the protection for their work. That's why it is always important to protect their work before publishing their work or before entering into the market. And registration is done by the sovereign authority. Rights are for the limited period of time. There is no automatic relief. That means, okay, I got a patent for my work, so now the government will take care of anything like that. This is not like that, because even if you get a patent, it is your responsibility to file a case against those infringers who are copying your work. So it is the responsibility of the person to file a case against the infringers. And we have to, the next point is renewal fees has to be paid for the IPRs. So till now we have seen what is intellectual property, what are its rights, what are the types of intellectual properties, and we have also discussed about patents, designs, geographical indications, trademarks, and we have also seen the validity. I mean, how many years we can get the exclusive rights. All these things we have discussed about it. So there will be a few questions, simple questions. You can answer that. So which type of intellectual property protects the paintings painted by artists? So can anyone answer the question?
Copyright.
Yes, copyright is correct. What protects the intellectual property created by fashion designers? Fashion designers.
Registered designs.
Yes, correct. So which of these is a geographical indication? The first one is BMW, it's a trademark. Venkatagiri Sari is a geographical indication because Venkatagiri is a place in Andhra. So it has a unique quality. So that is a GI. Ironing machine with stem comes under patents. PlayStation might also comes under patents. World Wide Web comes under copyrights. So next we will see where to approach for protection. So for patents, you can file for the patent in Kolkata, Delhi, Chennai, Mumbai, either offline or online. For designs, examination is done at Kolkata office, but you can submit the application in any office. That particular office will forward the application to the Kolkata office. And trademarks, offices are in Mumbai, Delhi, Kolkata, Chennai, Ahmedabad, GI, Chennai, and SICLD, it is Delhi. Copyrights, it is Delhi. So if you need any further information regarding the filing procedures or the drafting of the applications, you can approach Rajiv Gandhi National Institute of Intellectual Property and Management in Nagpur. Now we will see how the patent is filed in India and how we determine the patentability of an invention. So this is the simple representation of the patent granting procedure. So first the applicant file for the patent. After that, the office will publish his work in a patent journal. So after that, the examiners will examine the application. After that, a decision will be made whether to grant or reject the patent. If it is granted, again it will be published in the journal. So in the meantime of this process of filing and the granting, anyone can file for the pre-grant opposition, saying that suppose if I filed for a patent and the other person will think that I have got the patent in a wrongful way, or I'm using the patent for the wrongful deeds. In those cases, the other person will file a opposition on my name, say to the government. So if we found that that I am doing this in a wrongful way, after the grant of patent, he will file for a post-grant opposition. So as I said earlier, patent offices are in Mumbai, Chennai, Delhi and Kolkata. So people having address of correspondence in Andhra Pradesh, Telangana, Karnataka, Kerala, Tamil Nadu, Union Territories of Pondicherry and Lakshadweep comes under Chennai office. So they can file for the patent in Chennai offices. So types of application. First one is ordinary application. So if a person files for the patent application only in India and he is not going into the other countries, at the same time, he is not getting the priority from other countries, in that case, the application is called as an ordinary application. So application is filed only in India, that application is called as an ordinary application. Some cases, people from India or companies from India wants to file in the other countries, or other country people or companies wants to file for the patent application in India, in that case, they can choose two routes. One is conventional route and the PCT route. And there is another type of patent application, that is provisional and the complete specification in the ordinary application. So in ordinary application, for example, if you take a student, he will be doing the research work in his fourth year or third year. So he found that it can be patented, but he has not reached to the results, ending stage of the work. But he found that his idea can be patented. In that case, he can file for the provisional specification, and so he will be getting 12 months of extra time to file a complete specification. In other cases, like some companies will develop a product, so they wanted to check the commercial value of the product, whether the product has a commercial value or not. So in that case also, first they will file the provisional specification. So, and they will, because after filing the provisional specification, they will check whether their product can be commercially viable or not. After deciding, okay, our product has a commercial value, it can get protected and we will get a lot of profits from our product. After deciding that, they will file for the complete specification and it will be published in the government. Even in the meantime, if someone infringes his product, he has a proof that he has already filed for the patent in the office. So that's why in cases like where you need time for getting results of your invention, but you have got an idea that can be patented, or in the case where you want to decide the commercial value of your product, in those cases, first you can file for the provisional specification before filing the complete specification. You can file either online or offline, but if you are using any patent agent to file your application, so in that case, only online procedure is given. So this is our official website. You can see you can click on the commercial e-filing, where you will be redirected to this page, where you have to give your username and password to submit these forms. The first one is a form 1, that is application form. Form 2 is a provisional or complete specification, where the details of your invention is given. And form 3 is the statement of foreign filing. So as I said earlier, a patent can be filed in other countries as well. In those cases, you have to give that particular details in the form 3. Form 18 is a request for examination. So if you submit form 18, only then the examiner will examine the invention, otherwise it is not examined. So form 5 is a declaration to inventorship. Form 9 is for the request for early publication. Form 26, in case you are using any patent agents to file on behalf of you, in that case, we have to submit form 26. Proof of right is for the, suppose sometimes inventor and the applicant are different. So if you see any company, employers will do the research and the company will file for the patent. In those cases, those employees has to give the proof of right, saying that this is our invention and we are giving this invention to our company in the proof of right. So form 8, generally only the applicant name will be mentioned as a patent in the patent certificate, but even if you want inventor name in the patent certificate, you have to submit the form 8. These are the fees filing details. For form 1, it is 1600. So for other than natural person or educational institution or startup, it is 8000. Form 18 is for the request for examination. It is 4000. For the companies, it is 20,000. So for any further details of fee filing, you can refer to first schedule of the patent route. Expedited examination, generally a patent from the filing to grant takes a lot of time, maybe like 2 years or more than 2 years. In order to get your application to be examined in an expedited way, or you want a grant of the patent in a faster way, you can file for the expedited examination. This provision is given to only to startups, small entities. Applicant is a female. In order to encourage the female inventors and the female applicants, this provision is given. And if there is any departments of the government and other government establishments like that. So here you can search your application here. So if you enter your application number there, you will be redirected to this page where you can see the status of your application. So the examination will be like first formal examination, then technical examination. So formal examination is nothing but checking of the fees or required forms are submitted or not. So after the technical examination, it is the checking the patentability of your application. So after that, a report will be generated and it is communicated to the applicant. Then the applicant will try to modify the invention or make some changes, and he will submit again. So if the examiner is still not satisfied with the applicant's amendment, a hearing will be held where a technical discussion will be happen between the applicant and the hearing officer. After the discussion, they will decide whether to grant or refuse a patent. So now we will see how a patentability is determined for an application. So for an invention to be patentable, it should have novelty, inventive step, industrial applicability. And also it should not come under Section 3 and Section 4 of Indian Patent Act. First, novelty means the invention which you have submitted to the office should not be published in India or elsewhere, or it is not known to anyone in the society. In that case, we can consider that the so-and-so application has a novelty. So this consists of all novel features and the solution given is a novel one. Sometimes what the researchers or some students will do is they will first publish their work, and after that they will file for the patent. In that case, there is a provision. So suppose if it is displayed or exhibited in before a learned society, so after that publication, within 12 months, they have to file for the patent. So after deciding the novelty, we will check for the inventive step, where we will check whether there is a technical advancement in the application. After that, we will decide the inventive step. So after that, we will see the industrial applicability. That means whether the invention the applicant has given can be used in our, can be made or used in our industry. Industry doesn't mean that a physical industry or a factory, it doesn't mean like that. So whether it can be used by a person or not, we will check that. So under Section 3 and Section 4, there are some patent applications which are not given grant. For example, inventions that are related to known things like discoveries, those are not given patent. And also those inventions which are frivolous or which are obviously contrary to the well-established laws. So for example, it's a mere discovery. For example, Newton has discovered gravity. Gravity is already existing in our atmosphere. What Newton has done is he just discovered that. He has not invented that. So such discoveries are not given patents. And the other thing is like, poison is not good if anyone develops a poison in order to kill a person, so it is opposite to the public morality or public order. So in those cases also such things are not given patents, and some computer related inventions are not given patents, like that. Or medical method of operation, method of diagnosis, all those things are also not given patents. So Section 4 deals with the atomic energy, like the application consists of compounds like uranium, beryllium. So such applications are not given granted. They will be referred to the Department of Atomic Energy. So what is the difference between a research paper and a patent means? Research paper is nothing but the summary of what work you have done during your research. So you will submit that to the journal. Patent is your invention. It's like you're submitting to the patent office, and research paper is a technical document. It consists of all the technical features only. But patent is a techno-legal document, because with the patent, along with the invention, you are getting the rights for your invention. But in research paper, you are not getting any rights. You are simply publishing your work in a journal. But in patent, you are getting publication along with the exclusive rights. So suppose if your particular invention has any commercial, if your particular invention or work you have done has any commercial viability or commercially it is very good, you can earn more profits, and it has a commercial value, it will people will recommend or anyone will recommend to go for the patent because you are having a commercial value and you are getting exclusive rights. So patent will help more than the research paper. Both the research paper and the patent has its own advantages and disadvantages. So based on your application, based on your invention, you have to decide whether you should go for a research paper or patent. So definitely with the patent, you are getting the publication along with the exclusive rights. Section 29 to 34, as I said earlier, sometimes people disclose their work and then they will realize that they should file for a patent. In those cases, in some cases, this provision is given where the applicant can file for a patent before 12 months of the public display. But we won't recommend this in general because this is not an absolute right every applicant should use, because it's a decision of the controller here makes a matter. So it is recommended to, before entering into the publication or before displaying in the public domain, it is always recommended to file for a patent application. Either it may be a provisional specification or a complete specification. So it is recommended to file a patent before displaying in the public domain. So sufficiency of disclosure. Till now I have said about novelty, inventive step, industrial applicability. All these features the office will decide whether the application has novelty or not. The office will decide. But as an applicant, what is your responsibility is you have to clearly disclose your invention. It should not be too broad or it should not be too narrow. It should be in such a way that any person read your paper can be able to understand what the invention is about. So they have to clearly disclose their invention. So the application should consist of field of invention, background, summary, brief description, detailed description of the invention, claims, and the abstract. So we will be mentioning everything up to in the detailed description of the invention, but whatever mentioned in the claims will get protection. So whatever features you will disclose in the claims, it is like you are building a territory around the invention and you are telling to the other people that this is my territory, you should not enter into my territory. So claims should be drafted in such a way that you will get a protection, not too broad or not too narrow, but appropriate protection. Which section of the complete specification gets protection means, as I said earlier, whatever mentioned in the claims will be granted protection. Some people without knowledge, they will drag the claims in this manner, saying that I am the inventor of this application, I claim some reward, I need a patent for this application, like that. But this is a wrongful way of drafting a patent claims. So for any further information, you can refer to patent manual for patent office procedure and practices, this link where the information about the filing procedure, drafting of patents, everything is explained here. These are the basic timelines, as I said earlier. So within 12 months, one has to file a complete specification after a provisional specification, and request for examination is 48 months, and a pre-grant opposition can be filed before grant, and post-grant opposition is can be filed within 1 year of the grant of the patent. So the first certificate is where the applicant name is only mentioned as a patentee. So in the second certificate, if you see, even the inventor names are also mentioned in the patent certificate. So these are the patent search databases. So before filing patent, one has to do some search from their end also. So there are some free databases like IMPAS, Google Patents, eSpaceNet, USPTO, PatentScope, and there are some paid databases like Patsy, Total Patent One, STN, etc. You can take a screenshot of this. These are the most important links regarding the patent filing or the CRI guidelines, everything are mentioned here. You can take a screenshot. So career opportunities means having an intellectual property or any invention or like that, you can file for the intellectual property rights under patents or designs or copyrights. So after that, you can use that for a licensing, or you can get royalty for selling your work. Or if you have some knowledge regarding the filing procedures of patents or drafting, you can become a patent agent or a patent drafting specialist. And you can, if you have a knowledge about the such, or the, if you want to deal with the oppositions or freedom to operate of a patent, you can become a patent analyst. And you can also, if you are a law graduate, you can work in a trademark or copyright firm. You can join IPR cell or IPR policy in your institutes, or you can also join the government IPR office. So this is the end of the session, and this is the certificate will be given to the students, and this is the certificate given to the participating college. So if you have any doubts, or if you need many further information, or if you want to repeat some any concept here which we have discussed, you can ask now. Any doubts? You can also use chat box to ask questions. Any doubts?
Hello,
Yes, hello. You can use chat box also to type your question. Or if you want to share any of your experiences regarding the intellectual property, you can share here. If you have any doubts, you can ask. If you are not clear about what we have discussed here, you can ask. Or shall we end the session?
Ma'am, are we winding up?
If there are no questions, we can wind up the session, sir.
Okay. Is there any more questions? Anyone? Any questions? Okay. In that case, thank you, Lavanya ma'am, for taking a wonderful session on IPR. I would also like to thank the organizers, Jaren and Jerome sir of Marine College. They were behind the curtains in organizing all. Also, I would like to thank who are participating in this. Thank you for your active participation. Some of you have joined in Zoom, and some of you are joining from the classroom. Some of you are watching in YouTube, being actively participating in this session. Once again, thank you.
Thank you, sir. Thank you for coordinating with us, Jerome sir and Arun sir. Thank you so much. And I'm closing the session, sir.
You may close the session. So we are closing this. You can leave the meeting. All of you. Thank you.
So you can take the attendance and you can submit to me.
Yes, I'll collect it through class teachers because the class teachers are coordinating this. I'll collect the list from class teachers and I'll send it to you, ma'am.
Okay, sir. Okay. And certificates will be distributed within 15 days, sir.
Okay, ma'am. Thank you.
Okay. Thank you.